Another episode of the Counterlawfare report featuring Brian Vukadinovich, and we're honored to have with us today Judge Posner, who of course we've seen before on the program. The judge was with us once before with Jared and Elizabeth Beck. Gentlemen, thank you so much for joining me today. How are you both?
We're fine. Very good.
Good to see you both.
It's a high honor to have Judge Posner here with us. That's the highest honor we're going to be able to get on here on any show.
It's true. It's true. Judge Posner, you've been an advocate for pro se defendants. You've created the Posner Center for for justice for pro ses, right? Do you want to tell us a bit about that? When we first spoke, I think you were setting it up, and now it's actually running.
Oh, yes. When I was on the Court of Appeals for the Seventh Circuit, I became aware of the fact that the pro se appellants, or sometimes their appellees, they were not being treated well by the court. And the problem was that there were a bunch of employees of the court who were called staff attorneys, and their job was to analyze cases involving pro ses and send their analysis to the judges who had been appointed to decide the pro se cases. And the problem that I saw was that the staff attorneys realized that the judges, with exception of me, did not like pro ses.
Yeah.
And therefore, they would recommend to the judges that the judges turn down the pro se that the staff attorney had analyzed.
Right.
And I thought that was very wrong, and that, and I offered to the head of the staff attorney, I said, look, why don't you have the staff attorneys submit their recommendation to me before it goes to the judges assigned to decide the case, and I'll go over it and I'll edit their recommendation. And the head of the staff attorneys thought that was a good idea. But when the chief judge learned about this, she thought it was a very bad idea, that I should not be permitted to do that. And she enlisted the other judges to agree with her that the staff attorney recommendation should go directly to the panel of judges assigned to decide the case, and I should have nothing to do with it. And I didn't like that. And it led to a lot of disagreements between me and the chief judge. I realized that not only she, but the other judges, they didn't like pro ses.
Why do they not like pro ses, Judge Posner?
They didn't like pro ses because the pro ses didn't have lawyers. And their notion of, a litigant is someone who has a lawyer. Now, of course, it's not true. There are a great many pro se people who have legal claims, but they don't have a lawyer. And often, they're right not to have a lawyer, because they have a lawyer. That lawyer is going to be in conflict with the other side's lawyers and is likely to be outgunned. So anyway, I realized pro ses wouldn't do well in the Seventh Circuit. So I quit. And I retired, technically.
Now,
and,
Judge,
established a company which helps pro ses.
Right. Wouldn't you say, Judge, that it's really denying people their legal rights to a fair defense by being so prejudiced against pro ses? It really reserves justice for those who have the money for a lawyer.
Exactly. Yeah, because they think of pro ses as marginal people, and the judges, federal judges, only deal with, important people, important litigants who have important lawyers. So, and you can't really you can't purge the judges of that thinking.
Right.
So what we do, my company does, now it's more than a year old now, we do mainly coaching of pro ses. We could appoint a lawyer for a pro se. We've done it occasionally, but the problem is that the lawyer for the pro se is very likely to be outgunned by the lawyer, or more likely lawyers, for the other side. So we do instead coaching. So we say to the pro se, look, we're going to teach you how you can be, in effect, your own lawyer. This is how you should, and there are three elements of this. First, you've got to be very careful when you're talking to the judge. The judge is asking you questions. The judge is very powerful, and the judge probably is not very friendly toward pro ses. So you have to be very careful what you say. You have to be very polite and so on. A second, if you ask for a jury and the judge says, yeah, you can have a jury, you are going to have to be very careful in the way you talk to the jurors. You have to make clear to them that you have a serious claim and you're relying on the jury to give you a fair hearing. And then third, if the other side, as is likely, has their lawyers or their clients or what have you testify against you, you have to have, and will help you, you have to be, you have to know what you can say in response when they start questioning you. That's what we do now, and it doesn't always work, but it works better than if you try to give the pro se a lawyer, because that lawyer is likely to be outgunned by the defendant's lawyers.
So, Judge, what can you tell us about what's going on at the Posner Center of Justice for Pro Ses?
Well, I don't know. I have about 70 people. Some of them are lawyers. Many of them are what you call legal experts, legal consultants, but they're not practicing lawyers. And we assign them generally to coach the pro ses who ask us for help. So that, as I say, they can teach the pro se to be his own courtroom lawyer, and the way Brian Vukadinovich was. You can be your own courtroom lawyer. You can win a big case, but you have to think through it. You have to be analytical. You have to know how to talk to the judge, talk to the jurors, talk to the defendant's lawyers or witnesses if they assault you. And that's what we do, and it tends to be successful.
And of course, Brian is working with you there at the center, helping the pro ses to understand. Brian, is there anything that you want to add about the center?
Yes. Well, first of all, let me say that we, and when I say we, I'm talking about the entire country. We owe Judge Posner a huge debt of gratitude, because I know of no other judge ever, not just today, but ever, that, in fact, I'm just going to say it. When I picked up the newspaper and I saw the headline that Judge Posner was retiring from the Seventh Circuit after 36 years of service, for the reason that the judges on the Seventh Circuit were mistreating the pro ses, Judge Posner felt that the pro ses, just like anybody else, were entitled to their day in court, but weren't getting it. And he said that wasn't right. It was wrong. So when I saw that, I immediately said to myself, I have to reach out to Judge Posner, and we have to establish a relationship here, because I have never seen a judge ever stand up like he has done and criticize in a positive manner the judiciary to effect positive change. So, I just, we owe him a lot. Is there a noise? Is there a sound?
Yeah, what's happening is,
Yeah.
Judge,
I
do
hear you perfectly, yeah.
you have headphones, Judge Posner?
Do I have headphones?
Because I think we're getting feedback through your computer. The sound, I'm in a hotel right now, and the sound setup is not what I wanted it to be, so we're having some technical problems with the sound, and I believe we're getting some feedback through your computer. Headphones might help it, if you have them.
I don't have headphones.
Okay. So let's. It's a bit of a problem for me to address, unfortunately. Let me see if there's anything I can do. Give me just one quick second.
Should we not talk?
No, no one can hear you guys, unfortunately. I need 1 second.
I know I read an article where you had made your critical comments about the Seventh Circuit judges, and then I read in the article that Chief Judge Diane Wood took exception to your statements, and she said that, everything is great, everything is grand. She said she checked with all of the judges and everything, so forth. And I just didn't buy into that when I read that from her. And we have actually asked her, we have invited her to come on here and explain those types of things, but she will not come on the show. And I'm just gonna come out and say it. I think she's running and hiding. She doesn't want to come on here and take these questions, and we think that that's really a disappointment for our country, and specifically in the Seventh Circuit, that she won't do that. And we know that you're a proponent of cameras in the courtroom so that the public can see the proceedings. And we know that you had encouraged that to have happen at the Seventh Circuit. And we know that Chief Judge Wood told you that the Seventh Circuit they couldn't afford it. And we know that you actually told Chief Judge Wood that you would actually pay for that equipment out of your own money, and she still said no. So why don't you tell us a little bit about that?
Yeah.
She was very annoyed at my suggesting that I assist the staff attorneys to produce good analysis of the pro se case. She was very annoyed at that. And really annoyed, really angry. So what she did, after she told me that was impermissible for me to do that, she sent an email to all the other judges, and she never sent a copy of it to me, nor did the judges. But apparently, she told them all that Posner shouldn't be allowed to do this. And so far as I know, they either all agreed or they were all indifferent and would just let her have her way. Because at the end, I never heard from any of the judges or from her, except from her. She said, "No, you can't do this. You can't help these folks the way you want to." So she was very emphatic, and she did some strange things, I thought. She actually tried to get me tried, in effect, by a panel of federal judges in the Southwest, I think it was, and that they would decide that I was competent or something. And she never was able to get through with that. It doesn't have any legal status. You don't send a judge to be tried by other judges. So, but she kept hammering at me, and was very critical of me, and really quite nasty to me. And it became clear I wasn't going to get anywhere as a Seventh Circuit judge. I didn't get any support from the other judges who were intimidated by her. So I managed to retire, got a lawyer, dealt with her and her lawyers, and so I quit. So that was okay.
So, Judge, you know, Brian and I are frequently talking about lawfare. The show, of course, is the Counterlawfare report, and what you're describing is even as a judge, you were subjected to lawfare. They're using political manipulation and threats of prosecution to stop you from doing what's right. What can we do as citizens to help move forward this agenda to have cameras in the courtroom so that there's oversights over judges and more rights for pro se defendants? Is there anything you could recommend to our audience?
Yeah, although I'm not sure it's feasible. So in England, recently they have decided that all judges should be required to retire at either age 65 or age 75, depending on when they were appointed. So if they were appointed late in life, they get to 75. If they were appointed early, they get to 65. It's extremely sensible. But in the United States, the federal judges serve for life. And that's terrible because you've got these, octogenarians and nonagenarians who are far past their prime, not really interested in the work, enjoying the prestige of being a federal judge, federal appellate judge especially. And there isn't anything that can be done with it except for well, if you had a different kind of president and if you had a different structure of the Congress, you could change to the English system. But there's no push for that. So
there's actually one on the Seventh Circuit that's, I believe, 92 years old.
Yeah.
Right now. Judge Bauer.
That's right.
92 years old. And I'm not saying that somebody at 92 years old can't do the job, but that's pretty old.
Yeah. Also, I mean, Judge Bauer, we were friends. I liked him. He's nice. But
Judge, in your case, Judge Posner, age wasn't so much the issue, and I'm a little bit surprised to hear you calling out age. I agree that term limits for judges are important because irrespective of a judge's age, if a 40 or 50-year-old judge gets appointed and he knows he's got years and years with no need to be reelected, no oversight, it seems to be fertile ground for corruption. Just taking us back to Judge Woods for a moment, my understanding is your challenges with her had to do with her views on pro ses and her views on cameras in the courtroom. And to me, these are things that would preserve the rights of the individuals. If every federal court proceeding were, let's say, live streamed on YouTube or some other channel on the internet, people could watch that and the judges would know that what they do would be seen by the public. Now, you were a federal judge for many years and you've observed other federal judges. Is there a sense that the courtroom is the judge's private domain?
Oh, yeah. And, in a case of cameras, I offered to pay for the whole thing. And it just makes total sense to allow the public to see what the judges are doing. And there's a basis for that in other federal courts of appeals, particularly in California, where they had for like 30 years or something, they have broadcast all the appellate proceedings, and no one has criticized it, and I just couldn't understand why we should be doing the same thing. But she was adamant against it. I don't know why. I don't understand why.
Well, I would think it's because she doesn't want oversight. She wants to retain the ability to do whatever she wants in her courtroom, which she considers her domain. So it takes me to the question, if the federal judges won't allow it, how can we go above the federal judge? Can we go to our Congress people? Can we start a letter writing campaign? I feel very strongly that cameras in the courtroom are a major issue and something that Brian and I want to use the power of this social media platform to try to affect a change in that regard.
Well, you need the support of the you need the support of the big litigants, the big companies that that engage in television communications. They have political influence and so on. So they have to explain to the judges why they should be permitted to bring cameras into the court, what will be done with the information, how does it benefit the public. The model is California, which has done this for like 30 years without any problems whatsoever. And that's the procedure that has to be taken. And there have been companies who asked the Seventh Circuit to let them broadcast the arguments of the judges. And the court in Diane and Judge Wood's rulership have always refused, and I understand that. I know what they're worried about.
Something, if I could ask a question here, I read some information where you have written a lot of books, a lot of very educational books that tell us a great deal about law and so forth. And I read that you were actually in the process, toward the end of your time there at the Seventh Circuit, and you were being critical of the Seventh Circuit, of what was taking place. And I read that Judge Wood got upset about that and pretty much tried to put the kibosh to your book. And to me, as a citizen, to me that seemed like a prior restraint to say, I'm going to try to stop this person from publishing things so the public can actually know what's going on in the public business of the court. And then I have to wonder to myself, if she's telling Judge Posner, another federal judge, I have a problem with you publishing your book, your critical book about what's going on in the court system, I just have to wonder about how she's treating people's First Amendment cases when she's ruling on cases. Because prior restraint is, that's something that is very, very much frowned upon in our country. And from what I read, she was involved in an attempt of prior restraint on your book.
Now, just remember,
I know that you went ahead and published the book, and good for you, and good for the country for doing that. But having judges on there like that, resisting that type of First Amendment, is just indefensible.
Now, remember,
well, she was the first woman chief judge in the Seventh Circuit, and she may have felt that my opposition to her was based on hostility of women or something like that. So she was defensive about it, which women in influential positions often are. They feel defensive, they feel men don't really respect them. So that's a problem. But she overdid it, and I wasn't being disrespectful. I was just suggesting, we treat the pro se's better. That's all.
So, I don't think you were ever asking for any special treatment for pro se's. You were just saying, let's treat them equally. In fact, the courts all across the country, it says equal justice under the law in almost all of the courtrooms. And I believe that's all you were saying. You weren't saying let's give them preferential treatment. You were just saying let's treat them just like they should be treated, fairly.
Right.
And so for that, we thank you. I personally am just elated that you brought attention to this issue, because it's a serious issue in the country. We have thousands, maybe millions of pro se litigants across the country, and who are just getting shunned all across the country. And you stood up and you drew attention to it, and that's a big first step, for a positive change to happen. If you don't bring attention to the problem doesn't get cured.
Now, Brian,
and
remember, our audience
there are literally millions of pro ses in the United States. Yeah.
Please remember, our audience are lay people, not lawyers for the most part. So when you talk about something like prior restraint, Brian, what exactly is prior restraint? Is that trying to stop someone from doing something before they do it?
Before a publication, the courts generally feel that...
Sorry, Judge, could you turn down the volume possibly on your computer? We're getting very bad feedback. I'm sorry to ask you to do that, but I think it's causing a real problem for our listeners.
It's doing it for me. Hey, that's great.
Let's see if that'll help us a little bit. So prior restraint, Brian, is frowned upon because it's basically trying to shut somebody up when they're trying to point out wrongdoing. Is that it?
Absolutely. In fact, I think Judge Posner may be able to speak about the burnings, the book burnings in Nazi Germany way back in the day when Hitler was in power and ordered. They took all the books out of the libraries. They didn't want the people to have information. And so in our country here, we have a thing called prior restraint, where if somebody, just as Judge Posner was doing, he wanted to put information that the public should know about. It involved a public court, and the judge got upset about it because she didn't want the public to know what was going on. But the public has a right to know what was going on. And luckily in our country, we have prior restraint, where that conduct is not to be allowed. And she actually tried to do that. Judge Posner didn't allow her to do it. And in fact, I believe he went ahead and published the book. But that's what prior restraint is, to stop, to not allow a person of influence to stop. If there's a problem, if there's false statements made or whatever, there's remedies for that. You can sue the person and go for damages, but there's more harm by not putting the public information out. There's a remedy if you put false information. There's damages that can be awarded and so forth. But otherwise, we would have it would be Nazi Germany all over again,
Right.
And that was a form of it.
Oh, yeah.
Right. So we're basically asking for checks and balances in the courtroom. We're basically asking for individuals who have lawsuits or criminal suits brought against them to reserve the right to defend themselves. And this is really important, Judge Posner, isn't it? Because, we've seen several cases here on Crowdsource the Truth, and we've been examining on the Counterlawfare report certain frivolous lawsuits that are brought as punitive measures. Right now, I don't know if you realize this, but I personally am being sued by 2 individuals, and I don't want to go into the details of the case, but it seems quite clear that the purpose of the lawsuit is not to actually achieve relief for the complaint, but to penalize me through this process. These plaintiffs are trying to force me to hire a lawyer and go into financial debt to just before anything is even decided. And if you have your way, Judge, and pro ses are empowered through the Posner Center of Justice for Pro Ses, it would really minimize the burden on the courts, because people would be less inclined to initiate these frivolous lawsuits. Isn't that correct?
Yeah, I think that's true. Yes. Yeah.
Okay.
There will be always people who bring frivolous lawsuits because they're, not thinking clearly. They don't know what they're doing. That's unavoidable. That's fine. I mean, the courts can deal with that.
But the individuals who are subjected to these lawsuits, if the purpose of them is expressly punitive, even if someone knows there's no chance of winning the lawsuit, bringing the lawsuit, if you're, let's say, rich and powerful and want to suppress, let's say, a journalist who doesn't have money, you could sue that person for defamation, and before we even get to the truth or falsity of the claim, the person who is the defendant is placed under great financial burden. And in the situation as it stands, if judges have no respect or great disdain for pro se defendants, it makes it a pretty difficult situation.
Well, of course, if the pro se is being defamatory, then the defendant is entitled to, object and defend himself against the pro se suit.
Right. Now, Brian, you and I have been speaking with Michael Barden. Just today, he's told me that he intends to reject the plea deal and that he is fired his attorney. I hope that we'll be able to speak to Michael in the future. But Judge Posner, how would someone approach the Posner Center of Justice for Pro Ses if, let's say, they're wrongfully accused of a crime?
They'll call up me or call up someone else they know or know about in the company and explain their situation. And if we think there's merit to his case, we'll, let's say, usually coach him to be able to present his case by himself rather than having a lawyer. Because they say if he has a lawyer, the other side's probably going to have that lawyer and outnumber him and so on.
So would you say it's common for a pro se plaintiff and a pro se defendant to be engaged in a suit, or is it usually a lawyer versus a pro se?
There are suits against pro ses, but mostly the suits are by the pro ses, because usually the pro ses don't have anything worth suing them for. They don't have money. So, because if they had money, they wouldn't be pro ses. They'd have lawyers. So almost always the pro se is asking for something rather than being sued himself.
And in many cases, the pro ses that I deal with, that I talk with, don't have money because the lawyers have taken all of their mony.
That's a good point.
Consequently,
that's very serious. Yeah. I have this case in which I'm sure I've mentioned it to Brian. Probably a couple in California, and they had a best friend in Indiana. And the best friend called him up and said he was dying of cancer. He was in the hospital. And would they come and visit him? So they came to visit him, and he said to them, I'm going to die soon, and I'm going to give you I'll leave you all my money. It's $1 million. So fine, and they go back to California, and he dies, but he doesn't leave a will. So they go and hire a lawyer in Indiana and say, will you try to find the $1 million that he promised us? So the lawyer I think he spent a year, supposedly, I don't think this is true, but supposedly he was searching for the $1 million. And at the end of the year, he tells the couple in California, he says, well, I searched, and I couldn't find $1 million. So, but my fee for you is $125,000.
Ooh.
So they pay that, and they hire another lawyer. And it's the exact same thing. The lawyer spends a year or maybe 2 years in ostensible search, which obviously is nothing. And at the end, he charges them $250,000. I think they had another like that. And finally, it was after that, they called me and said, could I help them? And what could I do for them? And I was a little puzzled. It's new to me. But I spoke to one of the judges that I've been a colleague of, and he lives in Indiana, David Hamilton. He's a very good judge, very nice person. And I said, what should I do? You know, these in California, they've been taken for several $100,000, and I don't. What should I do to try to help them? And he said, well, the lawyer, there are actually three lawyers, not two, who had represented these people in a completely unhelpful fashion. He says, call up the heads of the law firms that these lawyers work for and see what you can learn about these lawyers from the head of the firm. So I call up the head of the firm. I talk to all three of them. And they all say the same thing. They sort of laugh and they say, these lawyers are the very bottom of our firm. They're no good.
Wow.
No one hired them to look for a large amount of money. They're no good. So they're sort of laughing about it. And I realized what this meant was that this couple in California, they would get nothing from suing these lawyers because the lawyers don't have any.
Right.
I mean, they had, they've gotten their $250,000 or $200,000, but probably had to give it to the firm. So, so that's where it stood, and I don't think, and they could. I mean, they wouldn't get anything from suing these lawyers.
Now,
And,
Judge,
yeah.
earlier this year, you added to the Posner Center. David, is it Boys? Is that his last name?
Oh, David Boyce, yeah, he's a great lawyer. I've known him for many years. He's not part of the Posner Center.
Oh.
Love to have
the case.
In the case. Sorry. So Brian sent me a few articles here. Perhaps we could talk about these. What was going on in that case with David Boyce?
Well, it starts a number of years ago. When I started in my company, I was contacted by a fellow in Baltimore named William Bond, Bill Bond. A very nice person. I've never met him. We've talked on the phone a lot. He's a big admirer of my cat. And when he writes me, it's always Dear Pixie and Dick. Pixie the cat. And he asked me for pictures of Pixie, and he sent me 2 porcelain cups, drinking cups, with pictures of Pixie on the cups. So he's a character. He's a real character, and he got into trouble of some sort. I don't know what. And I know it sort of worried the police in Baltimore, and they'd go to his apartment, and they sort of harassed him. And he didn't do anything really, but he was upset by them, and he sued, and the case wound its way through the sixth circuit, got into Virginia, and he lost in the district court, went up to the Court of Appeals. I lost there. I tried to help him, but I didn't get very far with it.
Right.
And finally, he decided to go to the Supreme Court. And we had a very good lawyer named Matt Dowd, who's also a member of my company. And he wanted Matt to represent him, and Matt didn't think he had a case. And he asked me to represent him. I said, well, I can't. I don't have any status in it's the 4th Circuit or 6th Circuit. But the judge of it, I wouldn't be in. Didn't make sense. I can find you another lawyer.
Right.
And finally, he ended up with David Boies as his lawyer. Boies is one of the very, very best lawyers in the country. I've known him forever. I have very high regard for him. So he has David Boies, and he's trying to get the Supreme Court to hear his case. He lost both in the district court and the court of appeal. So whether the Supreme Court will take the case, nobody knows.
Now,
But,
Judge, with regard to what we were discussing earlier, I've just looked up this matter of cameras in the courtroom, and it states that California law allows accredited news organizations to videotape, photograph court proceedings in the Superior Court if permitted by the judicial officer handling the case. I presume that's the judge, right?
Yeah.
So it's basically just saying that, yes, there's a law that seems rife with restrictions. I don't know what an accredited news organization is, what the credits come from. I guess maybe the court, but ultimately it's still up to the judge. And, you know, as we were presuming before, if a judge is engaged in wrongdoing or discriminatory practices towards a citizen wanting to exercise their rights to defend themselves in their own case, it seems like there's a lot of leeway there for them to not have the cameras in the courtroom. Brian, was there anything that you wanted to focus on in particular, or do we want to stick on this cameras thing? Because I'd like to really see if there's a way that we could collectively as an audience maybe...
Okay, let me respond to what you just said.
Sure.
I know you're talking about the state court system in California. My only familiarity with cameras in the court is in the federal courts of California. And there, the cameras are cameras owned by the court, and they just automatically film every argument in the federal courts of appeals.
Now that's a security camera, isn't it? Is that a security camera?
What's a security camera?
In the federal court when they're filming, those are security cameras, aren't they?
What do you mean by security?
They're not. The purpose of the cameras in the federal courtrooms, they don't really publish those out to the public, do they? The proceedings in federal court.
No, they do. They're focused. They're the cameras. The cameras film the argument, the oral argument, and then they're available to everybody. Yeah.
So I've just found this document here about
anybody in California can watch all or some of the, or if they want less than all of the federal courts of appeals there. So,
I've found a document here, gentlemen, on the... Sorry? I found a document here about federal courts, specifically about cameras in the courts, and it says the Ninth Circuit Judicial Court, in cooperation with the Judicial Conference, has authorized the three districts of the Ninth Circuit, District Court of the Northern District of California, District Court of Guam, and District Court of the Western District of Washington that participated in the 2011 to 2015 cameras pilot to continue the pilot program. So it does appear that there was some push for case video archive, and actually it looks like we've stumbled upon it right here. I think you might be able to even access some of the videos, and yes, here we go. So here's some video from the courtroom.
Well, wait, the federal courts in California have been filming oral arguments for 30 years.
Yes, but this seems to be a public record that's accessible on the internet in exactly the way that we're describing. I mean, again, to be clear, what I'd like to see is the ability for everything about a court proceeding to be streamed over the internet with the specific intent of the public acting as a check and balance against the potential possibility of a corrupt judge.
What do you mean by everything?
I mean,
we have a film of an oral argument. That's it.
See, we actually talked about a case on last week's show where the judge was actually, it was a criminal case in federal court, where the judge actually allegedly was sleeping during the trial. I don't know if do you remember that case?
No.
Rudy Lozano? The mayor, one of the mayors in Indiana was brought in on embezzlement charges of public funds. And the newspapers were reporting that he was sleeping, actually. And it went to the Seventh Circuit. And I recall that Chief Judge Wood, now, there was arguments. There was no doubt that his head was down for extended periods of time and so forth. Some were saying he was sleeping. Some were saying he was just relaxing a little bit, so to speak, to put it in a polite way. And it was, I honestly said to myself, he just handed the defendant on the silver platter a reversal. You can't have a judge sleeping, and that's just me.
So did that happen, Brian? Was there a reversal?
Well, there was no reversal, but Chief Judge Wood, her position was, well, they didn't prove that he was actually sleeping, and even if he was sleeping, the defendants didn't prove that he was sleeping during the crucial part of the trial.
Wow.
This is what I read. So Chief Judge Wood, her position was, well, we're not going to reverse the case, the conviction, but we're going to kind of keep an eye on things, on what's going on over there. So, sounds shaky to me. True story. A highly publicized case.
Judge Posner, you've never taken a nap during the middle of a trial?
Oh, no, I don't. But judges do say, some of my colleagues would occasionally fall asleep. But that was rare. That was rare. It may be more common in district courts, where a lot of the cases are, really marginal, and the judge just gets terribly bored.
Well, that's another great reason for cameras in the courtroom.
Right.
Of course,
we have to talk about it at the appeal.
Yeah. That's very important.
Now, if we could ask Judge Posner his feelings, since he was on 36 years reviewing court cases, one of the things that I'm very concerned about in the country is the very high, alarming rate of motions for summary judgment that are granted by the district courts. And for the audience, that's basically a dismissal of the case without a trial. It seems to me, from the research that I've done, there are way too many cases being dismissed. And I have to have a question about what the Seventh Amendment in our country means when the Constitution gives the people a right to a jury trial, and where the judges are, it's a very high percentage. The U.S. court system won't tell me what the percentage is. I'm trying to get the information.
Wow.
It's a very high percentage. What are your feelings? It seems to me like if there is a factual issue, to me it seems like the district court judges, there's a lot of creativity going on when they wanna go in favor of the corporation or a government, and far too often. And to me, I feel like if there's a factual issue going on, it should go to a trial. The jury should be determining that, not a judge.
Yeah.
Well, I conducted lots of trials in the district court when I was Court of Appeals judge. That's common. Well, not too, but Court of Appeals judges are authorized to conduct trials. And so I conducted a lot of trials. And if one of the parties wanted a jury, give them a jury. That's no problem at all. And I'd instruct the jurors, how they conduct their case. And I would interview the jury. I mean, in the courtroom. if one of the parties said, here are the jurors we'd like, I would interview those jurors to make sure that they were, minimally competent. And that really didn't create any problems.
Now, Judge, in 2017, a publication called Above the Law, it gave us the backstory behind your retirement. Of course, we've spoken a bit about that. Brian, you've sent a bunch of articles. Was there anything that you wanted me to refer to specifically? Because we are getting close to the end of our hour here.
A bunch of articles by me or about me?
About you when you retired. Yeah. One of the things that definitely got my attention was that you felt that the judges on the Seventh Circuit were treating the pro se litigants as trash, and that got my attention for sure. And I was actually happy that you said that, because it drew attention to the problem, and it is a problem. And it's just mind-boggling that they are treated as trash. I mean, let's face it, a lot of people don't want to say it. Maybe a lot of people don't want to, use that word, but that's exactly what they're doing. And had you not come along, because I feel that what you did at least draws attention to it, and also the judges, and every judge in the country knows you, so when you said it, it had an impact. And they're thinking about that now when there is a pro se litigant in their case. That's got to be in the back of their minds. So I did read that in that article, and it's a strong word, and I think it was the proper word to use, because it drew attention to it.
We had some terrible cases, and one in particular, a guy sentenced to prison. It was prison in Indiana, federal prison. So he shows up there, and he's sent to the medical, clinic first. That's routine for any new prisoner. So he goes there, and he's examined by doctors, and they say to him, "Look, you have a brain problem. It's a psychiatric problem. So that means you have to have a lower bunk in the
jail cell.
We've picked the cell for you, but because of your brain problem, you must have a lower bunk. You must have a lower bunk. Now, in many prisons, the lower bunk is taken over by the tough guy. But in this prison in Indiana, they had lots of empty lower bunks. So they send him off to a cell where there'll be an empty lower bunk for him. So he goes there, and there's a guard, and he says to the guard, "The medical people told me it was my brain tumor, whatever it was. I have to have a lower bunk, and I noticed, you have an empty lower bunk in this cell, which I've been assigned to." So this guard, an idiot guard, says to him, "Where's your document?" So he said, "I don't have a document. I wasn't given a document. They told me. You need to go to this cell and occupy the lower bunk." So the guard says, "No document? Upper bunk for you." So he goes to the upper bunk. Now, really, he has this brain problem. So after, a week or so, he falls out. And, the floor is concrete, so he's fallen from an upper bunk. He's seriously injured. He's sent off to a hospital. He comes back, and he... Okay, tell him it'll be just a minute.
Okay, it's 7 o'clock.
Yeah, tell him it'll be just a minute. So anyway, when he returns from the hospital, it's exactly the same sequence. He goes there, he says he's in the hospital, he's been told he must have a lower bunk of his brain problem, was exacerbated by the injury that led him to the hospital. And this idiot guard just said, well, where's your document? And I haven't done. They didn't give me a document. So I said, well, too bad. Up the bunk for you. And he fell out again later, a couple of weeks later, had a more serious injury, spent more time in the hospital, comes back. The warden of the prison does rounds. You know, she goes around all the different cell blocks, and her round takes her past his cell. And so he always says to her when she appears, and appears into the cell, warden, I was told by the medical people I had to have a lower bunk because of my brain disease. And she just looks at him. No, don't say anything. Just looks at him, and then she walks away. And she never, you'd think, well, after this, she'd call up the medical people, see who was, no, she never does that. So, finally he dies. He dies in prison. And it's not clear exactly why he died, whether it was this brain stuff or something else. But anyway, he's dead. But his family sues the hospital for neglect of him. And it goes to a district court. And the district judge, another idiot, the district judge says, well, I don't know, guard said he needed a document, so we're not going to interfere with this case. Not interfere. So the family comes up to the Court of Appeals, and I was on the panel of 3 judges. The other 2 judges voted to affirm the district court. I said, well, the district judge thought it was there. So why will we interfere? And I dissented, but it did no good whatsoever. No one paid any attention to this. So that's the problem. The courts don't, the federal courts do not.
Judge Posner, you were called the leader of a legal revolution by Bloomberg, in their online publication and their newspaper as well. That, of course, is your support of pro se's and all of the work that you do. It's interesting to me that you've written more than 3,300 opinions as a federal judge. Isn't that correct?
Something like that, yeah.
That's a lot. We're getting very close to the end of our hour. Brian, was there anything else you wanted to ask the judge? I know an hour goes quickly.
Yeah, well, there's a whole lot of things that I would like to ask the judge. I feel very honored that he came on. I think he has to go. I think he has a meeting coming up here. But Judge, we are so honored to have you come on here. I hope the people out there understand the magnitude of what we just did here, because I don't know if there's a federal judge in the country that's ever going to come on the show with me and Jason. Because we're telling it like it is about what's going on, and we're putting notice out there to the public that we need to have more fairness in our system here, and that's what you're all about. You've been about all fairness your whole life. You came on the show here and talked about it, so we're so very thankful to you for doing this for us, and we know that there are other judges that are watching this show as well. And we're hoping that they had their notebook out and they took notes tonight to see how a judge is supposed to be a judge. So hopefully they were taking notes tonight, because we had the best on here tonight for sure, bar none. Thank you, Judge.
Thank you. Okay, great. Thank you very much.
Thank you for joining us, Judge Posner. It would be nice to speak to you soon.
Thank you.
Take care.
Great.
All right. And with that, thanks for watching, everyone. This has been the Counterlawfare Report with Brian Vukadinovich, and we'll be back next week. Brian, I think next week perhaps we'll have opportunity to speak to maybe Michael Barden and get some updates on what's going on in his case there. I'm still hopeful that, Brian, maybe you and I can utilize this resource that we have here to affect some kind of change and to hopefully get some cameras in the courtroom. We had some sound problems there, so it might have been a little difficult to communicate with the judge, but perhaps, I mean, you know, obviously if it's the judges who are deciding if the cameras go in the courtroom or not, we need some way to go over the judges and try to ask someone else, if it's Congress people or what.
Well, yeah, I did some research on it, and the federal system is pretty much a uniform system across the board. They did the study they were doing that you were talking about there to see how it would go on some kind of an experimental basis. But it does go state by state, and I can tell you this: Indiana has a rule by the Supreme Court in Indiana. There are no cameras allowed in Indiana courtrooms. That's the Indiana law. Now in California, they allow them. We saw the O.J. Simpson trial, so it varies from state to state, and that needs to be changed for sure. It's just something that, you know, there's a lot of people that can't. There's elderly people, there's handicapped people that would like to watch trials and see what's going on. And unless there's cameras in the courtroom, these people are being deprived of that. And just the inconvenience of it. You know, I live out in the country. It takes me an hour to get to the nearest courtroom.
Well, so who would make that decision? Who could affect that change, Brian? Who could the people in the audience appeal to try to move the needle on this subject?
Well, as far as the state court system, the best way to do that would be to remember now. Courts need money, and courts receive money through the state legislatures and so forth. So the people need to contact their state legislatures and say, hey, listen, we want cameras in the courtroom, and you're milking us to death, taking all of our tax dollars. You ought to at least throw something out there to us and let the judges know that, you know, what's more important is, rather than judges just kind of being able to protect themselves, is the people having trust in what's going on in the system. So that's really the best place to start. Yeah. Sending, you know, letters to judges, writing letters to the editor of newspapers and so forth.
But we've seen, even in your case, we've got Judge Judy Woods is simply ignoring your letters.
Well, I'm glad you brought that up, because as a matter of fact, after our last show, where we had established that she's afraid to come on the show and answer our questions, and I'm going to say it again, until she comes on here, I'm just going to have to say that she's a coward. It's a cowardice act for her to come on here, to refuse to come on here, and I invited her again, and she just, well, the first time around when we invited her, we got some nonsense email from some unidentified person there that they don't want to tell us even who it is, so they don't even have the integrity to tell us who's speaking for her, even though we've asked. And then, so I sent her a follow-up email. Would you like to come on the show and answer some of these questions that we have? So the 7th Circuit Court of Appeals, it's a very large circuit, covers Indiana, Wisconsin, Illinois, Michigan, a couple of other states. We have a chief judge that is a coward who will not come on the show here because she knows that we have information of things that are taking place in the 7th Circuit that are highly suspect. Yeah. And she does not want to come on here and answer to that. That's the problem that we have in our country with these judges. Yeah. She shouldn't, in my opinion, she should not only not be a chief judge, she shouldn't be a federal judge at all.
I agree with you, Brian.
She should be working for the people instead of a secret court society that she's working for there in the 7th Circuit.
Yeah, I agree with you, Brian. I think this is going to be something that we will have to continue to revisit. I want to remind people that people can purchase your book. Oh, and I almost forgot to ask you, Brian, how did the book signing go there in Valparaiso at Barnes & Noble?
Well, thanks for asking. It was fantastic. I had a two-hour time slot from 2 o'clock to 4 o'clock, and they were, I don't know how many, I didn't ask them how many, but I know they were constantly coming over and putting books on the table. people would come, and then we would talk, we visited, and I signed them, and then they would run out of the books, and they had to keep coming back and putting them back on the table. It was so much fun. So many people came and wanted to know that this is the honest to God truth. I stayed there until they closed the doors that night. They had to unlock the door at 10 o'clock. I went into the cafe and talked with people. People were coming, and I told them, well, you know, when I get through here, we can talk more and so forth. And I stayed there till 10 o'clock. It was so much fun. And that told me that people are interested in what's going on in the court system. That was a very good barometer of that.
Well,
and let me just say, the Barnes & Noble people at the Valparaiso, Indiana store were absolutely fantastic.
Well, congratulations on a successful book signing. I feel a little bad to be showing the Amazon page, but I would also like to tell people that it's nice to see that the book is now available on Kindle. So for people who maybe want to have the convenience of having many books in their iPad or their Kindle device, you can now get Motion for Justice, I Rest My Case, for just $9.99 on Kindle. So that's very good. That's a new format this week that you didn't have last week. And it's also good to see, Brian, the used market for your book is holding the price very well. Frequently people will buy a book like Hillary Clinton's dopey book, and then there's so many people wanting to resell it that the price goes down to like $1.06. But even used books are holding their value well. So obviously Motion for Justice, I Rest My Case is a book that people want to read, and Brian has done really outstanding work in representing himself in these cases. I want to thank you, Brian, for creating this show with me. You've been watching the Counterlawfare Report with Brian Vukadinovich, and we'll be back next week. Brian will continue to delve into these subjects and more. Thank you so much, and have a great day, and I want to thank everybody for watching.
Thanks, Jason.